Hello and welcome. We're so pleased that so many of you can attend today and with the level of interest we've received for the event. My name is Chris Rance and I reside within the Whiplash reform team that sits within civil justice and law within the MoJ. If I could just turn to a few housekeeping points. If you wish to raise a question, there will be a Q&A at the end, and if you wish to raise a question, the Slido code is #M1103. We'll do our best to address the questions that we can at the end, but any that we can't or unable to address, we will follow up. This will likely be via the MIB eShot service. We'll be recording this and we would like to share it with you afterwards. The general purpose of this event is to provide an overview or update of the Whiplash Reform Programme and to provide an overview of the pre-action protocol and practice direction. I'll now hand you over to David Parkin, who also resides in civil justice and law and is the deputy director of that, and he oversees the Whiplash Reform Programme.
Thank you, Chris. Good morning, everyone. Just to reiterate, my name is David Parkin. I'm the Deputy Director of Civil Justice and Law at the Ministry of Justice. The Ministry of Justice you can see behind me, in fact, if I'm on screen. I'm here to talk about, with my colleague Jane Bowman later, the Whiplash Reform Programme. Ministers are implementing the Whiplash Reform Programme in May, on May the 31st this year, and we'll be hearing about the different elements of that reform programme this morning. I did want to say in my introduction, though, that we accept it has been a long time coming, the Whiplash Reform Programme, since the Civil Liability Act in 2018. We didn't appreciate or understand that we would be trying to implement within a global pandemic, for which we had to pause the reform programme for some months last year. And I think the time taken also reflects the need to get this right, because we do appreciate how important it is that the Whiplash Reform Programme is a success when we implement it. What I want to do today is just talk about some of the general updates on the programme and some of the general factors. Then I'd like to talk about the main elements of implementation, and then I would like to talk about some of the key issues that we either wrestled with and resolved, or still dealing with now just before go live. But I'd like to give an overview first before Jane hands on and talks about the detail of the programme. So first slide, please. Thank you. As I must say, the government remains committed to implementing the Civil Liability Act, and this reform sprint towards the end and the implementation sprint has been prompted by two particular things recently. First of all, the government laid in Parliament the draft Whiplash injury regulations, which set the final fixed tariff of damages for whiplash injuries. And secondly, the SI, which amends the CPR to increase the small claims track for PI claims arriving from RTAs to £5,000. These were both laid in Parliament on the 25th of February. The day after, the judiciary published the documents which underpin the Whiplash reforms and the online claims service, notably the new small claims pre-action protocol and the practice direction, PD 27B, if claims were not resolved within the portal. There are two critical milestones on the route to implementation. The third element of the implementation is the official injury claim service, which some of you have heard more about in webinars from the Ministry, from the MIB, and which you will no doubt be hearing much more in the coming weeks. They have just completed the 34th sprint, and it is almost complete. And that is the service on which all claims which have a personal injury element valued at up to £5,000 and an overall value of no more than £10,000 when you add other protocol damages, that is the service that will manage all claims of that nature. It is designed to cover both the tariff claims I mentioned and also non-tariff claims. And a key part of that and the implementation is awareness and communication. MIB have been communicating with professional users for some months now with mail shots on the service, And we're now ramping up both our online awareness service, of which today is one part, and the MIB are ramping up their technical build communications, of which I've mentioned several, and I will mention some in a moment. So everything, we believe, is set for implementation on the 31st of May. Next slide, please. I want to first go over the first element of the slide I mentioned previously, the draft Whiplash injury regulations. This is currently within Parliament. It's known as an affirmative resolution, so the statutory instrument will require debates in both houses of Parliament before it is settled in law. What the regulations do, and the SI does, is set for the first time properly the fixed tariff for whiplash damages, which has, in the table on this slide, the amount for the whiplash damages proper in the middle column, which begins £240, and alongside it, the total amount when you add minor psychological injuries as well, such as travel anxiety and shock. These are pretty the same since we implemented in, or set out in, the regulations in the draft bill in 2018. Have been upgraded for inflation. I've also been through consultation as required by statute with the Lord Chief Justice. So they've been pretty consistent and haven't changed fundamentally for 3 or 4 years now. The government believes that these whiplash tariffs are fair and proportionate and bring a better relationship between the nature of the injuries suffered by whiplash victims and the level of compensation, reflecting that these are not insignificant injuries, but they're not they're the lower end of the spectrum. Alongside the new whiplash tariff, we also provide for in the injury regulations the final level of the uplift, which we are giving the judiciary to increase payments under the tariff for exceptional circumstances. That uplift has been set at 20%, and it will be allowed to uplift whiplash damages where the whiplash injury is exceptionally severe or the circumstances of that injury itself are exceptional. Next slide, please. And the other part of the two legal documents and legal approaches we're implementing this spring before implementation is the pre-action protocol and the practice direction, which are on the judiciary website and the CPRC website. I won't say a lot about these because Jane will be dealing with this in more detail when she comes to her slide. So I will pass over those for the next slide, please. I wanted to say, in addition to the SIs that I set out, the pre-action protocol and the practice direction, what is still to be published. We have a suite of things on which we're finalising now, some with the assistance of the Civil Procedure Rule Committee subcommittee, and these are all due to be published within the next few weeks, hopefully the majority by early April. It includes not only the court forms and standard directions for the court process, but also the second and third bullets there, two really important bits. These are the user guides, the guide to making the claim and the guides to the court parts, which will assist litigants in person who we would not expect to dive into a pre-action protocol or a practice direction. These are simple guides, very accessible guides that will supplement the use of the online claim service and will guide people step by step through making a claim. We've taken a lot of care to get the language right on these. We have used experts in working with litigants in person to get the language just right. As I say, these will be implemented around April and form a key part of the implementation. Next slide, please. I just want to say a few words about the online service, which is the third of the three limbs after the regulations, the PD and PAP, and now this, which is the online service which will manage all future low value RTA PI claims. It's an online service with a telephone support centre designed with the claimant at heart, to be simple, user-friendly, modern, and will manage all these claims under £5,000. The MIB are currently doing an extensive communications programme, which includes, over the coming weeks and months, at least 5 e-shot demos, including on subjects such as non-vehicle costs and court forms and exit points in the coming weeks. The MIB intends to do an online end-to-end service clinic, which will demo the service towards the end of March, and then that will be before the MIB propose to release the training environment for service users in early April. And if you wish to sign up for those testing program or those webinars, then the service address is at the bottom of this slide, slide 7. And I do want to pause there for a moment and reflect on some of the criticism and concern about having a new Whiplash reform programme, which a lot of the work and the management of claims will be done by those who choose not to have a lawyer. They can still have one, but many people would decide, as the government anticipates and expects, that they can manage these claims themselves. Getting this online injury claim service is really important, and that's what we'll be working with you over the coming months to finalise. It's worth saying something at this point, and I don't often quote from the minutes of the Civil Procedure Rule Committee, but I'm going to on this occasion. There was a mention of our meeting in January when we were taking the rules through the CPRC. The impression of the CPRC subcommittee, which had had a run through of some of the screens, most of the screens, was that the portal build so far is impressive, user-friendly, and uses clear and accessible language, and we hope we can deliver on that for the whole of the service when we implement in May. Next slide, please. Finally, I just wanted to touch on a few of the key issues which we have been managing and looking at with ministers, with the CPRC subcommittee, and which are also for finalisation in the future. First of all, I'll take valuing claims and non-tariff injuries together. Users using the service and the online claim service will be managing the claim for themselves, should they choose to. It's clearly important that a claimant is able to value a claim at the start of that process and adjust their claim as it progresses. Importantly, to make sure that it remains within the limits that they can take it forward on the portal. Their medical reports will assist in the valuation of their claim, and it may be readjusted as they go along. The online service will be clear at the start and throughout how a claimant might value their service, their claim, both the personal injury part, including the whiplash and non-whiplash parts, and any protocol damages allowed. But what it can't do and does not provide is legal advice about what a potential claim is actually worth. The claimant may seek that advice from others, including their legal advisor or their insurers, but the online service does attempt to set out how they go about valuing the claim, which is helped, of course, by the tariff levels for the whiplash injury. In addition to the tariff for whiplash, the guide and the online service both will provide help and links to valuing the non-tariff part, with references to the Judicial College guidelines and other support and advice. So it signposts litigants in person to value their claim alongside all the other processes of how to actually manage a claim from start to finish. Clearly, there will be interest on the interface between the whiplash injuries in the tariff and those other minor injuries not covered by the tariff. Those There are concerns, which we understand, about the uncertainty and the effect on that interface, how litigants in person can value both, and what effect the tariff might have on the non-tariff injuries, on the minor injuries. Because of that, representatives of claimants and defendant sides, facilitated by the Motor Insurance Bureau and supported by MoJ, are currently meeting to agree and expedite some test cases to take to court so we can establish a process to value the non-tariff injury side, and hopefully we can expedite that soon. Turning to rehabilitation, the rehab is critical for most claimants, but what the service does not propose to do and is never intended to do is provide a service for booking a whiplash injury and organising a whiplash appointment at the same time as it provided medical report. So there is no rehabilitation service deliberately on the service so far. That is intentional, as I say. We wanted to focus on getting the injury part right and to implement this as soon as possible. But it will signpost the claimant to the importance of a rehabilitation and how to organise rehabilitation, but you cannot directly organise a rehabilitation appointment from the service. Finally, 2 points for the future. The suite of reforms we're implementing in May, as you may have noticed, do not include any changes at the moment to the employer's liability and public liability limit, which remains at £1,000. It's the government's intention to increase that, but ministers are currently looking at all their options for the future of ELPL, and will be deciding on that and communicating their intent in the coming months. And finally, I did want to say something about overall responsibility for the Injury Claims Service and its future governance. The Motor Insurance Bureau, as the delivery partner of MoJ, have developed the service. They are responsible for its IT build and the mechanics of the service itself. They do not control the service, nor do the insurance industry. The responsibility for the policy and the overall direction of that service lies with the Ministry of Justice and with ministers, not with the Motor Insurance Bureau. To reflect this, going forward, running up to implementation and afterwards, we will be establishing a governance system around it, which will be managed by MoJ, but will feature on it as an advisory group a range of representatives, including representatives from the claimant side, representatives from the defendant side, and a representative from the Civil Procedure Rule Committee. So there will be input and opinion on the operation of the service from all sides, and it will not be a matter of the MIB running the service at all. They will have no direct role in that decision making whatsoever. So I just wanted to set out those views, some of the points that we're considering, and some of the main features of implementation of the Whiplash Reform Programme as we head to the 31st of May. I'll now pass over to my colleague Jane Bowman, who will look at the pre-action protocol and the practice direction in a little more detail.
Good morning and thank you, David. Could we move on to the next slide, please? So I'm here, as David said, just to take you through in a bit more detail sort of some of the key aspects to pull out of the new protocol and the new practice direction. So if we focus first on the structure of the RTA small claims protocol, as sort of David has previously said, whilst the protocol is designed to be accessible for unrepresented claimants, they're also going to be assisted throughout by the portal screens. And in terms of the structure of the protocol itself, after setting out the general aims and scope of the protocol, the key sections are as outlined on the slide. And what we're going to do in the next few slides is just concentrate on those in a little bit more detail. Moving on, please. So first of all, to focus on the small claims notification form, as we said previously, the portal has been designed with the unrepresented claimant at the forefront of the approach. And the intention of the new portal is that it helps capture all of the key information needed to complete the small claims notification form. And this detail is very similar to the information which is currently required in the current CNF, so it isn't a vast distance away. Compensators will have more time to respond, so they will have 30 business days or 40 if it's the Motor Insurance Bureau, and this will enable them to obtain the statement of truth from the defendant. The claimant and the defendant statements may need to be copied into the court papers in due course, so this makes the whole statement of truth on both sides very important. Cases where liability is in dispute will not just fall out of the process, as happens in the current portal. If liability is genuinely in dispute at this stage, there's always the option for the claimant to go to court, and we'll focus on that a little later when we look at the practice direction. So then focusing on liability specifically, as we said, liability disputes do not exit the portal. In response to the small claims notification form, the compensator needs to indicate their position on liability, and they will have, as you'll be aware, 4 options: liability admitted in full, liability admitted in part, liability denied, or the fault for the accident is admitted in full or part, but there is a dispute that the accident caused any injury. Unless liability is admitted in full, the compensator will need to set out the defendant's version of events and provide evidence in support. If liability is admitted in part or an admission of fault is made, the compensator must include a percentage for which they admit liability or fault, and then the claimant has the option to start negotiating with regards to this percentage. If liability is denied, then the claimant can proceed immediately to the court process, as we sort of already outlined. So then moving on to initial medical evidence. During the small claims notification stage, the system will help identify whether or not there is likely a whiplash injury present, and then that will feed in turn into the medical instruction. The online injury claim service and Medco systems are fully integrated, and therefore unrepresented claimants will be able to source their own initial medical report directly via the portal. They will be able to make a selection of either a direct medical expert, a DME, or a medical reporting organisation, an MRO. There will be a new offer governing the number and type of results an unrepresented claimant will get to choose from. This is currently under development, and we will be publishing that shortly as well. The system will assist the unrepresented user by pulling in the details of their injuries from the small claims notification form and preparing a letter of instruction to the expert. And then either once the examination has taken place, either the DMA or the DME, or MRO will be able to upload the medical report to the portal with an indication of the prognosis given and from what point, either the date of the accident or the date of the examination. Represented claimants will be able to will continue to obtain initial medical evidence via Medco separately to the portal service, and it will be the claimant's representative's responsibility to upload the medical report to the portal, again with the indication of prognosis given. Also, it's worth having a look at the protocol because there are further details in there about what happens if a claimant lives outside England and Wales, and a little more about what happens if further medical reports are required. So once this has happened, we can then move on to consider losses, offers and negotiation. The claimant, whether they're represented or not, will be able to upload the details of their losses and their supporting evidence as they progress through the portal service. When they've reached the point of sort of having uploaded the necessary evidence and when they wish to seek an offer, this will be requested from the compensator in a fully itemised format. The compensator will have 20 business days from receiving this request for an offer to respond with the same. it's important to note that the compensator will make the first offer in respect of the injury and the uplift elements of any claim, and as David detailed earlier, obviously that could be up to 20%. And then once this happens, the parties can make up to 3 offers each to seek an agreement. So, you know, if there's further debate in relation to the offer. Basically, at any point in this process, the claimant can always opt to proceed to court if they feel that their claim is not being sort of taken forward satisfactorily. The other important thing to stress is that all payments are organised and made outside of the service. So effectively, once the parties have agreed on the offer, it's then, you know, it's something to be progressed that's outside of the portal. Focusing just a little more now on tariff damages, uplift in exceptional circumstances, and non-tariff damages, so the specifics. As I just outlined, the compensator is responsible for inputting the tariff figure first, and this shouldn't be an issue. There is scope to dispute the tariff amount if the wrong prognosis bracket has been selected from the tariff, or, for example, if the minor psychological injuries have been missed. So it isn't sort of it isn't you only do it once and you can never go back and sort of correct things. Both the Whiplash tariff and the tariff which covers whiplash and minor psychological injuries are available to both parties as well. As stated earlier in relation to the uplifted tariff damages, Section 5 of the primary allows for the uplift in exceptional circumstances, and the exceptional circumstances are deliberately not defined because obviously that will quite often be particular to an individual claimant. If this is claimed and the compensator accepts it's justified, then they should enter that percentage uplift of the tariff amount up to 20%. Once there's an offer amount of uplift in the system, the claimant then has the option to accept, reject or negotiate in respect to that figure, or they can obviously seek the court's determination. For non-tariff injuries, those injuries outside of the definition of whiplash, they will be dealt with in the same way as they are today. Whilst they're not subject to the same pre-medical offer ban in Section 6 of the Act as whiplash claims, the medical report is still recommended and will be required for the whiplash element in any event. The guide to making a claim, as David mentioned earlier, will direct claimants to the relevant sections of the Judicial College guidelines to assist them in valuing the non-tariff elements of their injury claims. This will be really important, both to help them know that they're starting their claim in the right place, but also that the portal remains appropriate as the value of their claim develops over time. And one of the things the guide makes clear is obviously that the claimant will need to continue to check the value of their claim and where it's getting close to limits. Moving finally on to there will, of course, be instances when interim payments are also being sought by a claimant. So where liability has been resolved in full or in part, i.e. at court, or the liability fault has been admitted in full or in part, the claimant may request an interim payment at any time. The compensator will have 15 business days to respond to the request. If the compensator fails to respond in this time or does respond and disputes the request, again, the claimant can proceed to court. The remaining portal process can proceed whilst the interim payment issues are being addressed by the courts. So it doesn't effectively stop everything. Things can still progress while that element is being sorted out. Just to reiterate again a few key points with regards to payments more generally, the portal system does not deal with payments. Where a payment is due or agreed, the compensator should make arrangements to deal with the payment outside of the service. And again, if the payment is overdue, the claimant can proceed to court to enforce the agreement. So they're the key changes in the new protocol. I want to now sort of briefly explain the link between the portal and court proceedings under Practice Direction 27B. Next slide, please. So the portal is designed to help the user prepare the small claims notification form. It's designed to help the user prepare the court claim form and obtain a decision from the court at different stages if it's required. So a user may, for example, issue a claim early on to resolve a liability, but once that's sorted, they can come back into the portal to continue with their claim. Proceedings are possible for the following reasons, and these are sort of outlined in the practice direction, but they are sort of liability dispute only after full denial of liability, assessing the value of the claim, and there are different variations here, so including liability being accepted in full but no claim for uplift or vehicle costs, liability accepted in part but it's not agreed around the uplift or NVCs, liability is accepted in full, the claim including uplift or NVCs, liability is accepted in full but the uplift is an issue, where the claimant's seeking interim payment, or the claimant has not received payment for an agreed interim payment, where proceedings might become necessary in light of limitation, whether there's a dispute over disbursements, an agreed settlement amount has not been paid. So, and each of these 10 different options do have their own section within the practice direction 27B. Next slide, please. The final area sort of to consider in the protocol is the issue of non-protocol vehicle costs, or NVCs. The key thing to sort of say is these damages mirror the vehicle-related damages that's in the current RTA portal process, and they're only included if the claim is exiting for value to be assessed by the court. There is a comprehensive definition of vehicle costs generally in the protocol, which I'd urge you to look at, but in short, where the claimant has not paid these costs, so for example a credit hire or a storage charge met by the insurance, these are not included in the portal process until it's necessary that they become included for proceedings. The system is designed to help the claimant ensure that these NVCs are introduced at the right stage and with the right supporting evidence. Next slide, please. So moving on, we want to now just focus on practice direction 27B in just a little more detail. The first area to highlight is actually its structure. So section 1 of the practice direction is setting out the various general points applicable to all types of claims. Sections 2 to 11 then relate to the different options outlined, which we've just discussed previously. When we looked at the links between the portal and proceedings. Once you've identified the claim type in question, i.e. are you, I don't know, issuing for limitation or interim payment, you then therefore only need to read section 1 and the other relevant section from sections 2 to 11. As David sort of alluded to earlier, we are intending to publish a short guide shortly to Practice Direction 27B, and this will, for litigants in person and unrepresented claimants, highlight the structure because obviously they're less familiar with the process. So the intention is that this will be clear, easy to read, and will make it, if they need to refer to it, clear what bits might be relevant in any particular circumstance. As I just mentioned, obviously, section 1 is covering the general provisions that are relevant to all the 10 claim types, and it sets out the following key points. So basically, which of the 4 court forms will be required? As we've previously said, actually, the portal will prepare these for users based on the information provided throughout the process. So it sucks in the information already given. It also sets out the allocation to the small claims track. It sets out second defendant situations. So, for example, where the MIB or other RTA insurers are relevant. It says when cases should exit into the fast or multi-track, so due to their value or complexity. And it also looks at the effect of admissions within the portal. As the practice direction has now been published, I would like to suggest that it would be useful to make sure you take the time to familiarise yourself with the detail, particularly in section 1, bearing in mind it's relevant to all cases. And as I've sort of said, for each of the different reasons for going to court, the portal will assist the claimant preparing the claim form, and it will attach all of the necessary documents and evidence particular to the reason for the litigation. So it's intended, hopefully, that the claimant is generally doing things once, and it can be extracted and used for proceedings as appropriate. The other key points to note about the workings of the practice direction is that after the portal has assisted the user in preparing the court pack, the case will continue on the basis of that evidence unless the court specifically allows for any further evidence. An oral hearing with directions from the court will be put in place where liability is an issue, or if there are other contested elements, such as the non-protocol vehicle costs are an issue, or if there's no agreement on an uplift in tariff damages. Where only quantum is an issue, so those issues without MVC or uplift, no directions are expected, and the court will deal with those matters without a hearing, which is similar to the sort of stage 3 paper hearing that takes place currently. The latter sections of the practice direction, so sections 7 to 11, are also expected to be dealt with on paper, basically without a hearing. The other thing we wanted to say is, one small but important point is that the days in the practice direction are calendar days, as with the rest of the civil procedure rules. So days are only business days in the context of the time limits within the new protocol. So it is important to be aware of that distinction. You should also note that the appendices to the practice direction that's currently published contain standard directions and details of what information will go into each court pack. As indicated earlier, the standard directions are currently being updated, and as David outlined, we hope that we will be able to publish the new ones by early April. Finally, next slide, please. Whilst I've focused a little bit in detail on the RTA Small Claims Protocol and Practice Direction 27B, there are a number of other amendments to other rules, protocols and practice directions to be aware of. Some of these are more substantial than others, and I thought I'd just mention a few key ones that it might be worth familiarising yourself with. So they are to Part 26 on case management. Firstly, this will outline whether different claim types, for example, for children or protected parties, are to be brought and which track is applicable to them. Again, as David said earlier, we are intending to publish a separate guide on the changes to Part 26 to assist with clarity for unrepresented claimants so that they're very clear where they should be. Another key amend is around Part 35 on experts and assessors. This is where changes will introduce the concept of the whiplash injuries in the specific context of the Civil Liability Act, and how fixed cost medical evidence should be attained in respect of this pre-action protocol. And then Part 45 on fixed costs. Sorry, this is where the cost implications of failing to comply with or continue under the RTA Small Claims Protocol are set out. As noted previously, there are other amendments which include to parts 14, 16 and 46, but those are summaries of the key ones. So that concludes sort of the overview of the key points I wanted to sort of draw out with relation to the new protocol and Practice Direction 27B. And I will now hand back to Chris for the question and answer session.
Jane, thank you for that. That was a really helpful update and offered some great insight into the reforms. So yeah, as expected, we've received a number of questions. We've sort of highlighted a few that we think will be of general interest to most on the call. So we'll begin. So can a claimant include a claim for rehab in the portal claim and list of losses under other protocol damages, as these are stated to include any liability for the claimant to repay another person or business and costs of treatment, including rehab arranged by the representative with deferred payment?
Yeah, thank you, Chris. I'll take this, and I'll probably take the next one to allow Jane to gather her thoughts for a moment. Yeah, when I was talking about rehabilitation earlier, I was talking about the inability to source and organise a booking for rehabilitation, but rehab itself can be claimed through the portal service as a normal protocol loss, including where that loss is ongoing. Credit rehab is included within this. The exclusion elsewhere for claims made in respect of liability to repay another organisation is targeted at vehicle costs and not targeted at rehab.
Thank you, David. Move to the next question. I think you kindly offered to answer this one as well. So when will the guide to litigants in persons be made readily available?
Yeah, I think we touched upon that once or twice in the talk, but just to confirm, we hope to make it available in early April. But just to emphasise, this is a guide intended and written very much for unrepresented claimants. The legal profession, we expect, will read the protocol and the rules, which are already published as usual, and clearly from the other questions we're getting, they are already doing so.
Thank you. That's helpful. Moving on to another question that we've received. Like I say, we have received a number of questions. We won't be able to address them all today, but we will definitely follow up on them. And we're just highlighting some that will be of particular interest, shall we say. So are we able to explain why we did not allow any provision to return an SCNF to the service where the compensator is identified incorrectly? Goes on to say, it is wrong to assume that DVLA / MID will be correct every time, as bad data as bad data in will equal bad data out.
Yeah, so thank you for that. I mean, I think basically we concluded that in the service where, you know, we've got unrepresented claimants, we can't have a situation where effectively they're left in limbo while different insurers are arguing about who's responsible. So consequently, we came to the conclusion that if the insurer is identified on MID and the case is passed to them, then they will have to deal unless they can persuade another insurer to take over from them. This also means that basically the claimant will only effectively have one set of time limits for the liability response, so that things aren't being deferred endlessly while there's ongoing arguments. And meanwhile, you know, the case doesn't progress. So the idea is that this was meant to provide some certainty for the unrepresented claimant.
Thank you, Jane. Moving on to a further question. So this individual says that at the last webinar, they raised an issue about how claimants are expected to know that their claims are worth more than £5,000 from the outset. Goes on to say, this was not really answered, and the response given was that this was an issue. How will this be addressed if the issue is known? If it is known issue, sorry.
Yeah, thanks, Chris. I'll take this. And I alluded to this valuation point during the talk earlier. Obviously, the ultimate value of any injury claim cannot be known with certainty at the start of the claim, and that will be no different in future as it is today. But the user will be assisted by the online service and the guide to help them understand what level of tariff will apply to their injuries. The service will also link users through to the relevant extracts from the Judicial College guidelines to help them estimate the potential value of their claim at that early stage. But obviously not all claimants will know right at the start, and that will remain permanent. For some, it will be a dynamic valuation as the prognosis changes, depending on the nature of their injury and its extent.
Great, thank you for that. Moving on to a further question. Here we go. Will further guidance be released about exceptionality?
I'm happy to take that one. I mean, I think as I alluded to earlier, it won't be possible to provide further guidance. I mean, it's defined in I think it's section 5 of the Civil Liability Act, and what constitutes exceptional will be very much sort of down to the individual claimant. You know, everyone's circumstances will be different. I mean, I think ultimately the Act will have to be interpreted by the courts to sort of see what they think will be categorised as exceptional. But I don't think we would want to provide guidance, because trying to cover everything would probably be a very challenging task. So no plans to.
And it's worth Chris. Thank you, Jane. Just picking off a further question, which has pretty much the same answer in a sense. Question later down on the chat says, can you provide a couple of examples of exceptional circumstances that result in the uplift? And the answer is we can't, as Jane said, can't really provide examples at the moment to interpret what is ultimately a statutory definition.
Thank you both. That was really helpful in understanding that point. Further question: what do you suggest an insurer does that cannot obtain notification of RTA from a PH? There is no provision to acclaim WOP as RTA insurer, and there is no option to allow the CNF to time out. Further, there is no option to deny liability without your PH version of events.
I'm happy to take that. I mean, the portal does allow an insurer to sort of set their status out to the RTA insurer when they're providing their response. I think there is a paragraph in the protocol 6.16 or something which explains the effect of such a response. If proceedings do become necessary, then the portal will have to take the claimant through the process of issuing against the driver and against the insurer as the second defendant. And it would then be, I think, for the court to make a standard direction allowing the RTA insurer to sort of exercise the rights of the first defendant. As I sort of alluded to earlier, the standard directions are currently being updated, so hopefully this will help make things clearer, and that will assist the process.
Thank you for that. Further question: if a claimant has a standard whiplash injury, neck, back and shoulder, but has a separate injury to the knee, this individual says, I'm assuming this can't be dealt with in the new portal. Are claimants able to use the old system, and will the old portal costs still apply?
Thank you, Chris. Actually, that is half right, but not, because under the new system, the protocol on the portal is actually designed for the situation set out. That is, where there is a whiplash injury and another injury, or even another injury on its own right. Your personal injury or combination of injuries can be dealt with by the protocol on the portal. The key thing is that the overall value of the injury element must be less than £5,000 or £5,000 or less. If it's over that £5,000 limit, then the current portal is merely the starting place for that claim to be taken forward under the old system, where, as the chat says, the old portal costs will apply. So it's evaluation that's the important thing there.
Thank you. It's interesting. Moving to another question. When dealing with a soft tissue whiplash and a secondary injury, for example, wrist or elbow, surely the secondary injury is now the primary injury in relation to the compensation it will attract. Are we expecting to see a continued increase in non-whiplash injuries?
I mean, to be clear, obviously the service will monitor in time the trends about what is being claimed. So we will see if behaviours and what happens practically does change over time, shall we say. I mean, ultimately, the claimant must only claim for the injuries they've genuinely sustained, and this is where the statement of truth is very important about, for when they're submitting their claim. It will be for the courts to obviously determine the level of the damages to be applied for the non-whiplash injury alongside the tariff, and that's something we will obviously continue to observe and see what happens. So, like I said, this is something I think that as the service beds, as the new service and process beds in, we will then see what the behaviours are, and then increasing data will enable us to sort of monitor that aspect.
Thank you for that, Jane. Moving on to another question. It looks like the official injury claim final code will now be released in May and not April. How are API companies expected to be linked and to have staff trained on new systems in such a small timeline? Are they really 98% ready?
Thank you, Chris. Yeah, it's a very good point. We have seen a number of questions referring to the OSE code releases. These are not something the MoJ can answer today. They're points for the MIB, and this point, and in fact all the other points that we're receiving today, which really are for the MIB, we will pass to them straight away for them to consider.
Thank you, David. That's helpful. Moving on to another question that we've identified here. It again relates to exceptional circumstances. You touched on this earlier, David. I will read the question out in case you want to say anything further, or Jane for that matter. Can you provide a couple of examples of exceptional circumstances that might result in a 20% uplift in damages?
Yeah, I think there's probably nothing more to add on that point right now. Thanks, Chris.
That's fine. Thank you. Okay, we'll move to another question in that case. In cases that are denied on liability, are the courts ready for an influx of these liability-only cases where the claimant is a litigant in person?
I mean, you know, obviously we've been working very closely with HMCTS to make sure that we can understand and resolve or mitigate any operational impact of these reforms on the court system once they go live. I mean, you know, as everyone will be aware, the courts are obviously used to dealing with unrepresented claimants or litigants in person at small claims hearings and all different sorts of disputes. So the work we're doing with HMCTS is obviously getting things ready in terms of, you know, whether it's forms or some training or, you know, just to bring them up to speed. So I think that, you know, so they fully understand what they're doing once the new process goes live, and we've got every confidence that that will be in place and be sorted.
Thank you. We have a question here about medical experts that I think would be of interest. Will the medical experts know the tariff bands? Will they know to not advise of an injury prognosis that stretches across two bands? If they do provide a prognosis across two bands, which band will be used to value?
Yeah, it's a good point. Yes, we expect fully the medical experts will be aware of the different bands, and throughout this process we have engaged with Medco, and the necessary training will be provided to medical experts and MROs, and we fully understand, and they should understand what they will need to do when the time comes to work within the bands.
Thank you, David. In line with that, we have a further medical related question. If a second report is required, such as an orthopaedic or psych, will Medco offer this service on the portal? If not, how would a litigant in person know where to obtain this?
So, I mean, the quick answer is no. Medco will not offer the service through the portal. Actually, the unrepresented claimant will be able to request this report and have it organised by the compensator. Although the report will still obviously need to go to the claimant first for them to consider before it's disclosed. So the first expert will obviously need to identify that there is a requirement for a second report, but the idea is that this is something that the claimant is requesting, and obviously the compensator can then organise.
Thank you, Jane. That's really helpful, offering that insight into that. Moving on to another question that'd be of interest. When negotiating, is it expected that offers will be made within 10 days? However, there are no time limits sanctions on this. Why is that? Well,
there is time limits on the initial offer, obviously, but there are no formal time limits for future negotiation, and parties we expect should engage sensibly. They're encouraged to negotiate without a whole slew of additional rules, and we expect them to do that, and our experience of other online systems suggests that people will respond quite quickly without the additional time sanctions and limits that this might otherwise involve.
Great, thank you for that. another question here. Do we have any plans to link the OICP and the rapid, in brackets, i.e. RTA portal at any stage for cleaner claims flow?
No, I mean, no, there aren't any plans in place to link the two. I mean, I think our expectation is that sort of over time, the use of the RTA portal is likely to reduce. But I can't say that we have any plans to link anything, so no.
Okay, thank you for clarifying that, Jane. Moving on to another question. Do you expect to make any further changes or updates to the civil procedure rules? If so, when would you expect this to happen?
Thanks. I set out in my talk at the start where there are still documents and guides and helps to be published. So that sets out the suite of documents for pre-implementation. We don't expect anything else to be published via the CPR before the 31st of May, but clearly the rules will be kept under continual review by the Civil Procedure Rule Committee, and those rules will be updated as and when required, but that will be obviously in the hands of the committee rather than MoJ.
Thank you for clarifying that, appreciate it. At the moment, we can deal with innocent parties without prejudice, brackets WP. The new rules state that an omission on one claim may be binding for other claims related to the same accident. Does this mean then that we can no longer deal with innocent parties on a WP without prejudice basis where there is a driver dispute?
So my understanding is that the rules don't say that. So I think in the practice direction, there is a paragraph 1.9 or something that the court will take it, and then the court can take into account the an omission in another claim, but will obviously decide on the evidential weight to give it. So I'm not sure that the question is quite right, if that makes sense. But yeah, no, the rules don't say that. Okay,
thank you for that, Jane, David. We're getting through a large number of questions here, and I think that's really useful, and I hope those on the call will find it useful as well. I'm sure they will. Just to reiterate again, like I say, we won't be able to cover everything because the large volume of questions, but we will certainly follow that up, definitely. Right, okay, moving on to another question I can see here. I apologise. Sorry, I had a slight technical issue there. We're getting through a vast number of questions. That's really helpful. Moving on to a further question. You say the portal will signpost claimants on what to do to get rehab, and then it goes on to say signpost to where.
So, basically the portal and the guide will explain to the user where they might be able to access rehab if it's required. This may have been obviously organised by them directly or via the compensator. So, I think it's something, that, like I said previously, it's that there will be a bit of a discussion in terms of between the compensator and the claimant, but obviously the guide and the portal will also do some explaining about how they might access it and just put a bit more further context around it as appropriate.
Thanks, Jane. That's helpful. Like I said a moment ago, we're getting through a lot of questions here, and we've got a couple of minutes left to answer what we can. Just to reiterate, we will of course follow up anything that we can't answer here.
Chris, sorry, can I interrupt?
Sure.
And just say we've got a minute left, and can
yes,
I just
absolutely.
can I pick out perhaps a final question from the chat that I think is important and relates quite widely, and that's data. One of the questions asked, what industry level data will be made available post implementation, and when can we expect the first distribution of this? And I think the answer to this is we're still working up our plans for data, and we haven't yet finalised what we will make available post 31st of May. But the interesting and quite exciting thing about the online service is that we will generate significant amounts of data, which will be useful to both MoJ and MIB, but across the industry, and will help us understand the behaviour, user satisfaction, how litigants in person are managing the service, and whether the intentions for the online service and the Whiplash reforms are actually being achieved. I think there are good arguments for making that data available quite widely, both to across the legal sector, but also to regulators and others. But we just need to decide how to do that, the extent to which we can do that, and then decide that and release what we can after implementation. But it's clearly one of the key parts of the service that will generate much richer and better data about a whole range of things that we can use to refine the service and perhaps point to further reforms if any part of the service is not quite working.
Great, thank you for that, David. I can see we've gone past 10:30 now, and the scheduled time was indeed until 10:30. So unless you have any closing comments, David, Jane, I think we'll, as I mentioned earlier, we'll follow up on any questions that we didn't reach, and thank you for all who have attended.
Yes, thank you. We will try and answer as many of the points as possible by another method and another route, but thank you all for your contributions today. It's been really helpful.
Thank you. Goodbye.